Hello and welcome to Mackenzie Friend. Today we're going to look at drafting family law parenting affidavits. But first, the usual disclaimer. Whilst I hold a law degree majoring in family law, I choose not to practice nor seek admission. Therefore, any information cannot be relied upon. Specific questions should be directed towards an accredited family law specialist. Okay, let's look at what is an affidavit. What should it contain and what should it not contain? What is an affidavit? An affidavit is a written statement of relevant factual material prepared by a party or witnesses that a party intends to rely on as evidence in court. An affidavit is the main way a party presents evidence to court. An affidavit must be properly sworn or affirmed by the party that is relying on it. What should an affidavit contain? Well, the affidavit should contain detailed facts to support what is sought. Only material that the party personally experienced, heard or saw. The person can only give evidence of that which they have personal knowledge. Now, it can also contain, say, expert opinion in the form of, say, medical reports, plus perhaps police reports, and if you have annexures, that the affidavit should reference those annexures. So what should an affidavit not contain? Well, inadmissible material, such as legally and properly obtained material, such as recordings, GPS tracking, hacked emails or Facebook accounts, fabricated evidence, because some of this would be in contravention of the Surveillance Devices Act, it's in New South Wales, or other similar state acts. Also material that is unfairly prejudicial to a party, that might be misleading, confusing, or cause or result in undue waste of time. Hearsay, because the person who is attesting to the affidavit was not present for those conversations. Opinion, or speculation, unless that person is an expert. Character evidence, which is a bit tricky. Past behaviour, and legally privileged information. So you can't attach, say, correspondence you had with the other party's legal representation, because that material is in confidence and without prejudice. Same way with material that could be part of mediation or settlement negotiations. Also material that is irrelevant, that is speculation or conclusion, that contains submissions or case law. Now, inadmissible material can be struck out if we see 15.29 of the Federal Circuit Court rules and 15.13 of the Family Law rules. So let's have a quick look at the court rules. Now, the rules relating to affidavits are in the rules about evidence. So you can see Chapter 15 of the Family Law rules and Part 15 of the Federal Circuit Court rules. The following of an affidavit does not make the contents of the affidavit evidence. It is only when the affidavit is relied upon by a party at a hearing or trial that it becomes, for that hearing or trial, subject to any rulings on admissibility, part of evidence. Affidavits are filed as prescribed by the rules or as directed by the court, or if leave is sought and given by the court. Although the rules do not state that all evidence of your client has to be in one trial affidavit, you will need leave of the court if you wish to rely on any affidavit your client has filed early in proceedings. Now, this is important because it's important the court has one document they can refer to. It's very difficult if the information or material relying upon is spread across multiple affidavits. You might know in some matters, when the matter is going to final hearing, the court will require a trial affidavit which contains the most up-to-date affidavit for both parties. Also, you need to look at the practice directions, because practice directions also dictate the length and the number of annexures for certain applications before the court. Now, affidavits have to be in a certain format. Under 24.01 is the general requirements for documents being filed on the court registry. It says that affidavits must be single-sided, be printed or handwritten in black ink, have margins wide enough to allow documents to be bound no wider than 2.5 centimetres, have line spacing not more than 1.5 lines, have page numbers numbered consecutively, be stapled or pinned or otherwise fastened, bear appropriate identification, parties and court numbers are set out in the rules. Also, it probably speculates the size of the text. Now, if we look at 15.28 of the Federal Circuit rules and 15.12 of the Family Law rules, the exhibit pages must be numbered and must include the title and number of the proceedings. Both annexures and exhibits must state that the person making the affidavit identified the particular annex or exhibit at the time they were making the affidavit. The cover sheet for each exhibit annexure should be witnessed. Now, formality. As I said, the affidavit must be witnessed on each page, and any affidavit you file in court to support your case must be served on all parties. That's just a matter of procedural fairness. So let's have a look at some drafting tips. Now, first, I think you need to look at the orders you're seeking, because the affidavit is intended to support the orders being sought. Now, I think it's best to also start with a chronology, so you can easily see when events occurred and what happened. Now, think about what the party is trying to prove. Also, you need to start with a brief background, and that might be the dates and places of birth of the parties and any children, the dates of the parties becoming Australian citizens or gaining permanent residence, dates of cohabitation, marriage, and final separation. Also, avoid detailing the party's complete life story. There's a case there, Shinan and Shinan, which has a little interesting comment upon that. And be concise in identifying the issues in contention. Now, create a list of all the headings for all the matters you need to consider, including any relevant issues about the timing of your application. The affidavit can be either chronological, which is traditional, or topic-based, and particularly address issues of family violence, because they're often a significant concern in family law matters. Also, look at the 60cc of the Family Law Act considerations. Now, we know that 2A and 2B, the benefit of the child having a meaningful relationship with both of the child's parents, and the need to protect the child from physical or psychological harm from being subjected to or exposed to abuse, neglect, or family violence. These two issues are the most critical. Also in 60cc3, which is the additional considerations, any view expressed by the child, although a parent bringing the views of a child to the court is a little bit questionable and probably should be brought by proper means, by either, say, the ICL or the family report writer. And also you might want to consider the nature of the relationship of the child with the child and other persons. So you might, in your affidavit, talk about how the child spends a lot of time with their grandparents and other friends and family. That's important to the child and their stability and their well-being. Also, the extent at which each child's parents has taken or failed to take the opportunity to participate in making decisions about major long-term issues in relation to the child, spending time with the child and communicating with the child. So it's a bit silly to say seek orders for equal care when the party isn't even exercising their care that they have under their interim orders. So looking at a few more 60cc considerations, you might want to talk about the fun things you do with the child and your ability to meet the day-to-day needs of the child. So there's the fun things and there's also the practical things, like taking the child to school, making sure they have their lunch, making sure you buy clothing for them, all those sort of day-to-day fundamental issues, attending medical appointments. And also the practicality with complying with the orders sought, like if you're a fly-in, fly-out worker, it may be difficult to have week-about arrangements. So you've really got to think about the orders you're seeking and that how you can practically comply with those orders that you're seeking. Now, also the capacity of the child's parent to provide care and needs of the child, including emotional and intellectual needs. Now, sometimes in a matter I dealt with a little while ago, one party had cancer, and so there was always going to be an issue whether or not that cancer was going to affect that parent's ability to provide care. Also, if the parent has mental health or substance abuse issues, that would be an important consideration. Also, the issues of maturity, sex, lifestyle, religious and cultural backgrounds. There are specific provisions in the Family Law Act that pertain to Aboriginal and Torres Strait Islanders. Now, the responsibilities of parenthood is just demonstrated by each of the parents. You want to show that you've got an active involvement in the child's health, education and welfare. And also there's always a catch-all under 60cc3 of any other relevant consideration that you think the court may attach significance to. Now also you want to sell yourself a little as to why it's in the best interest of the child for the child to have a relationship with that parent. Also completing old parenting or anger management courses or negative substance abuse tests can be beneficial. Sometimes a parent will make an allegation that the other parent is an alcoholic, And instead of just contesting it, it might be easier just to go out and seek a range of tests that prove otherwise. And that sort of takes the wind out of the sail on that argument. It's cheaper than trying to argue it in court. And it was likely that the other parent will make negative allegations. So you can't take it personally. You just have to know that this is how the adversarial nature of family law works. Now, there are exemptions to the admissibility. However, but for this to occur, the probative value must outweigh any prejudice. Also, when you're writing an affidavit, just use short sentences with one idea per paragraph. This is particularly important if the other side seeks to have parts of your affidavit struck out. They can only struck out smaller chunks. Also, don't lie, because if you get caught, it may irreparably damage your credit and the merit of other representations you make. Also, have another person read the affidavit for spelling, grammar, and coherence. Often you read it yourself, you miss things, particularly spelling and little things. And remember, the judge is going to read this, and so you want to convey the best position possible. So, in conclusion, affidavits are a statement of truth about facts relevant to the matter before the court. So you need to be concise and confine the affidavit in support of the order sought. Avoid inadmissible material if at all possible. You can raise concerns about the other party if appropriate, but avoid the concern being considered as denigration. There's concern and there's denigration. So you're raising concern, but denigration is you're actually attacking the other person. The court will be attentive and act cautiously in the presence of family violence. And finally, drafting an affidavit is a skill. Even if you cannot afford representation, having your affidavit looked over by a lawyer is advantageous. Hope this helps.